Welcome to Talking Business, your straight talking guide to dealing with corporate matters. Whether you are a private or public company, an owner managed business or an entrepreneur, a director, company secretary, or in house counsel, this is the podcast for you. My name is Sophie Brooks, and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Hi everyone, I hope you're all well. So this month I've got 3 interesting cases for you. So we've got yet another unfair prejudice case. We've got an attempt to challenge a government decision based on national security grounds. And then I've also got a case that highlights the dangers for an LLP, a limited liability partnership, of not having a bespoke partnership agreement in place. But first up, this month's big news is that Companies House has confirmed that its new identity verification requirements are going to come into effect on the 18th of November 2025. And at the same time, there's going to be some significant changes to the registers of information that a company is required to maintain. So both of these changes are the result of the implementation of provisions in the Economic Crime and Corporate Transparency Act. So you might have heard that referred to as ECTA. So in relation to identity verification then, so the point at which an individual needs to verify their identity depends on their position and whether they already hold office on the implementation date. So from the 18th of November, new directors will need to verify their identity before they are appointed to a company or before incorporating a new company. Existing directors of companies on the 18th of November. So they will need to verify their identity before the company files its next annual confirmation statement after the 18th of November. So there's a little bit of a transitional window there. For PSCs, so people with significant control over a company. So if you've got a new PSC, then after the 18th of November, then they will need to verify their identity within 14 days of being added to the Companies House register. For existing PSCs, the position is slightly different depending on whether or not they are also a director of the relevant company. So if you've got an existing PSC that is also a director of the same company, then effectively they have to complete their identity verification before the company files its next annual confirmation statement after the 18th of November. So when you do your identity verification, you get a personal code, and these people will have to provide their personal code as a director when the annual confirmation statement is filed, but they only need to provide their code as a PSC within 14 days of the filing. But I guess in reality, they're likely to do it all at the same time when that confirmation statement is filed. But then the final category is existing PSCs who are not also directors of the same company. So they have to verify their identity within 14 days of the first day of their birth month after the 18th of November. Sounds a bit confusing, but basically, if you were a PSC born sometime in May, then you would need to verify your identity before the 14th of May 2026. Okay, so those requirements are also going to apply to individual members and PSCs of limited liability partnerships from the 18th of November. And then at a later date, which hasn't yet been confirmed, the requirements will also be extended to limited partnerships, to corporate directors of companies, to corporate members of LLPs, officers of corporate PSCs, and also those people who file information at Companies House. But we're waiting for confirmation on the timing on those bits. So the other change that I mentioned that's coming into force on the 18th of November relates to a company's statutory registers. Sometimes hear those referred to as a company's statutory books. So from the 18th of November, a company will only need to maintain an internal version of its register of members. And what that means is that a company will no longer need to maintain its own versions of a register of directors, a register of directors' residential addresses, a register of secretaries, and a register of PSCs. So instead, what the company will have to do is it will have to file all the required information about those other registers at Companies House. So basically, the Companies House record is going to become the definitive version of those registers. So the register of directors, register of secretaries, etc. So, Companies House have previously said that all of these changes were going to come into force sometime in autumn 2025. So, confirmation of a firm date, the 18th of November, one that's towards the end of that window of autumn 2025, is quite welcome, I think. It gives companies, directors, PSCs more time to get up to speed with the requirements and get those verification requirements done. But, if you're an existing company and your next confirmation statement is due on, say, the 19th of November, then your directors need to have completed your identity verification by that date. Companies House have estimated that there's up to about 7 million people that are going to need to verify their identity under these new requirements. The good news is that it only needs to be done once, even if that individual holds multiple positions across multiple companies. Each position would just be linked to their verified identity using the same Companies House personal code. And in addition, the other good news is that identity verification is largely going to be a one-off requirement that you aren't going to have to repeat each year. So we've got that deadline, 18th of November. So if you are a director of a company or a PSC in a company, then I would strongly recommend that you look to verify your identity now. You can do it already on a voluntary basis at Companies House. You don't have to wait until your deadline. Okay, let's move on and look at the cases that I mentioned then. So first up, we've got this unfair prejudice case. Now, I've talked about unfair prejudice a few times before, but as a reminder, a shareholder can petition the court to intervene when a company's affairs are being conducted in a manner that is unfairly prejudicial to the interests of some of its shareholders, including that petitioner. And if the allegations are made out, then the court has pretty broad powers to make whatever order it thinks is fit, and that could include ordering the purchase of the shareholders' shares or maybe regulating the company's future conduct. So, in this particular case, we are dealing with a company that was incorporated in 2010 and it sold home brewing kits. Now, the company's founders had made substantial loans to the company, and in September 2018, they entered into a shareholders agreement, and I'm going to call that the existing shareholders agreement. A few years later, in 2021, an external investor subscribed nearly £1 million for shares in the company, which implied that the company had a total valuation of about £45 million. The subscription terms were documented in a subscription agreement and a separate nomination agreement. Now, the subscription agreement provided that the parties would, in good faith, use all reasonable endeavours to amend the corporate documents, whatever they were, to align with transactions for independent investors in startups. And it also said that any new shareholders agreement would be substantially like the existing shareholders agreement, but it would also contain provisions regarding various matters, including relating to the repayment of the founder loans. The separate nomination agreement stated that the investor would be entitled to nominate someone to the board. So later in 2021, the existing shareholders agreement was terminated, by a deed of release made between the company and all its shareholders, including that new investor. But crucially, there wasn't a new shareholders agreement put in place. Now, the next year, in 2022, one of the founders converted over £1 million of their loan into shares as part of a £6 million share offering to existing shareholders. But the investor subsequently filed a petition alleging unfair prejudice, and they said that there had been unfair prejudice on three separate grounds. So, the first of those is the board seat allegation. So, here the investor said that the company had failed to permit the investor to nominate a director in breach of that nomination agreement that I mentioned. The second allegation is the failure to amend allegation. So the investor said the company had breached the new subscription agreement by failing to use reasonable endeavours in good faith to amend the existing shareholders agreement to include the required provisions. And then finally, there was the dilution allegation. So here, the investor argued that the issue of new capital, including that conversion of founder loans into equity, had diluted the investor's shareholding. So those were the grounds on which the investor said it had suffered unfair prejudice. When it came before the court, the judge granted a summary judgment against the investor's petition on all the different allegations. So, taking each of those three specific grounds of unfair prejudice that the investor alleged. So, first of all, in relation to the board seat allegation, the court said, well, the nomination agreement conferred only a right to nominate, not a right to appoint a director. And a right to appoint would need to be in a shareholders agreement or in the Articles of Association. So, in relation to the failure to amend allegation, the judge said the relevant obligations in the subscription agreement were just good faith obligations, but they weren't promises. And a failure to achieve amendments to the corporate documents didn't in itself constitute unfair prejudice. What the investor would have had to have shown was that the company had breached its promise by acting in bad faith. And then finally, in relation to the dilution allegation, the judge said that the relevant share offering had been made on favourable terms to all the existing shareholders, including the investor. So the investor's decision not to participate couldn't give rise to a claim for unfair prejudice. So basically, it had had the chance to join in, and having declined and decided not to, that wasn't unfair prejudice. So I think there's a couple of lessons here from this case. Firstly, I think it highlights that an obligation to use all reasonable endeavours in good faith to do something doesn't guarantee that the particular something, the desired outcome, will actually materialise. All it does is oblige the parties to try to reach an agreement, but not to succeed in actually doing so. And then I think the other really important thing is that it emphasises the distinction between a right to nominate a director and the right to appoint a director. So a right to nominate, which remember is what the investor had in this case, just gives the right to suggest a director whose name would then get serious consideration from the company for the purposes of appointment. So if what you're actually intending is that a person nominated by a shareholder must be appointed as a director, then that needs to be clearly and unambiguously set out either as a right in the company's Articles of Association or in a separate shareholders agreement between all the parties. Okay, so the next case is the national security one that I mentioned. So in this case, the High Court upheld a final order that had been made under the National Security and Investment Act 2021. And that order required a buyer to divest its entire shareholding in a semiconductor company that it acquired. So this is actually the second application for judicial review of a final order under that National Security Act. And the High Court's rejection of the application to review the order, I think, reinforces the government's very robust powers under the Act, and it sets really quite a high bar for a successful challenge to similar orders in the future. So, as a bit of a recap on the National Security and Investment Act, what that act does is it allows the government to scrutinise and intervene in certain acquisitions and investments that it perceives could harm the UK's national security. So, specified transactions that occur in one of 17 high risk sectors of the economy have to be notified to the government's investment security unit before completion takes place. Other transactions in scope of the regime could be called in for assessment if the government reasonably suspects that they could give rise to a risk to national security. Now, a controversial aspect of the call-in regime, which is relevant in this case, is that it was implemented retrospectively. So certain in-scope transactions that completed before the Act came into force on the 4th of January 2022 can still be called in for review. Importantly, any call-in notice relating to a retrospective transaction must be issued within 6 months of the ISU becoming aware of it, and no later than January 2027. So there's a 5-year cut-off date after the implementation of the Act. So in this case, the buyer had acquired just over 80% of the shares in a Scottish-based company that develops semiconductor devices and related software. The acquisition completed on the 7th of December 2021. So that's the month before the new regime actually came into force. So the buyer in this case was a UK registered company, but that was ultimately owned by 5 Chinese funds, and the general partner of those funds is a Chinese state-backed private equity company. So on the 23rd of May 2023, so that's about 18 months after the transaction completed, the ISU became aware that the buyer may have acquired the target, leading to a call-in notice being sent to the target in November 2023. And the target then subsequently forwarded that call-in notice to the buyer. The government made a final order in November 2024 that required the buyer to divest its entire shareholding in the target. And the reasons for that, so basically the national security risks that the government said were arising from the transaction, were said to be that UK developed semiconductor technology and associated intellectual property might be transferred to China and deployed in ways contrary to UK national security. And then also ownership of the target could potentially be used to disrupt parts of the UK's critical national infrastructure which used the target's product. So the buyer launched judicial review proceedings, basically challenging the government's final order, and it did that on 6 different grounds. They included that the call-in notice wasn't served in time, that the Secretary of State was aware of the acquisition more than 6 months before the call-in notice was sent, so it was effectively out of time, and that insufficient reasons for making the order had been provided. Now, when it came before the court rejected all of the buyer's grounds for challenge, except for its argument that insufficient reasons for making the final order had been given. But the High Court held that this procedural flaw didn't invalidate the order because the evidence showed that the Secretary of State did actually have sufficient reasons for making it. And also, it was clear to the court that Parliament didn't intend that any or all non-compliance should invalidate the final order. Now, in relation to the timeliness of the call-in notice, the court confirmed that the 6-month clock under the Act starts when relevant individuals within the ISU not only become aware of an in-scope transaction, but also that the particular transaction may require investigation and potentially the exercise of powers under the Act. And that awareness wasn't restricted to the personal knowledge of the Secretary of State, but instead it could be met by the ISU staff actually tasked with carrying out the investigative functions under the Act. Now, on the facts of this case, the call-in notice had been served within those required time limits. And also, it said the court said that service on the target, as opposed to the buyer, remember that's who the call-in notice was sent to. The court said that didn't affect the timing because the notice had been sent to an email address which the Secretary of State reasonably believed would bring the notice to the attention of an appropriate person. So, like I say, this was the second judicial review of an order made under the Act, and as happened in the first case, this decision really signals that the courts are strongly inclined to uphold government orders made under the Act, and I think indicates that the prospects of a successful action for judicial review are really very limited. I think it's pretty difficult to see what grounds a successful challenge could be made on. I think this case shows that provided the Secretary of State has sufficient reasons to make an order, then a procedural failure to adequately communicate those reasons won't invalidate the order. Challenges based on the proportionality or irrationality of any decision are also going to face a high bar because the courts have shown really quite significant deference to the Secretary of State's assessment of national security risks and what they think the appropriate remedies are. Any challenge to the 6-month awareness period for calling in a transaction also has to factor in when the ISU became aware of the national security significance of a trigger event, not just the fact that a trigger event existed. So, on the basis, I think that the Act was drafted to give wide governmental discretion when assessing national security risks, it's maybe not very unsurprising that, in the absence of clear procedural unfairness, then the courts are going to continue to uphold Secretary of State decisions, I think. Right, our final case then. So, this one involved the High Court holding that the transfer by a limited liability partnership, so an LLP, of its entire property portfolio was invalid because it didn't have unanimous member consent. And the case highlights the significant and often, I think, unintended consequences of an LLP not having an express agreement in place, which means that the statutory default rules apply to the operation of that LLP instead. So the affairs of an LLP are usually governed. If you've set up a limited liability partnership, you usually also set up an express agreement between the LLP and its members. And that sets out the rights and duties of the members between themselves and the LLP, including, for example, how decisions relating to the LLP's business should be taken. But you don't have to have a bespoke agreement. There's no legal obligation saying that you have to have that formal LLP agreement. And if there isn't one, then there are some statutory default rules that basically fill in the gaps. Those default rules can be useful in that they provide some much needed certainty, but they can also impose different or stricter requirements than the members might otherwise have chosen in an agreement. So the particular default rule that was subject of this case states that ordinary matters related to the LLP's business can be decided by a majority of its members, but a change in the nature of the business of the LLP requires unanimous consent of all the members. So the case concerned an LLP whose core business was holding 3 properties. It had 2 members. I'm going to call them R and P. And importantly, there was no agreement in place governing the affairs of the LLP, so those default rules that I've mentioned applied. So in 2015, the LLP made a declaration of trust under which beneficial ownership of the 3 properties was purportedly transferred to a new entity that was just controlled by one of the members, P. Crucially, the other member, R, didn't sign this declaration. Now, the LLP was dissolved, but it was then later restored to the register in 2022. And R brought a derivative claim on the LLP's behalf, arguing that the transfer of the properties was invalid. R claimed that as the transfer changed the nature of the LLP's business, it required the unanimous consent of the members under those default rules. And R, who was one of the members, had not consented to the transfer. So the court, when it came before the court agreed with R and held that the declaration of trust was invalid. So the court found that the declaration had resulted in a fundamental change to the nature of the LLP's business. Apart from a bit of limited invoicing work, the LLP's whole business had been the holding of the 3 properties. And basically that business came to an end with the declaration. So the court said, well, stripping out all or virtually all of a partnership's assets and bringing about its dissolution couldn't be regarded as ordinary matters. So it was this fundamental change in the nature of the LLP's business. So because there was no express LLPment in place, the default rules applied, and that meant that unanimous consent from all the members was required for this fundamental change. And because R hadn't consented to it, the declaration was held to be void, meaning that the 3 properties were still beneficially owned by the LLP, and R and P shared equally in the LLP's capital and profits by default. So although it's I think maybe it's a bit unsurprising that the disposal of all of the LLP's assets amounted to a change in the nature of its business. This case is quite useful because it's a bit of a rare judicial interpretation of the LLP default rules that I've mentioned. And it also acts as a reminder of the importance of having a carefully drafted LLP agreement that governs the relationship between the LLP and its members and expressly outlines the procedural requirements for all decision making. Now, I know I'm a lawyer, so I would say that. I would say you need to have a proper agreement. But the lesson from this case is that without that kind of thing, then the LLP and its members is going to be required to comply with the statutory default provisions, which potentially, as in this case, could lead to invalid transactions and costly litigation, something that I'm sure everyone would rather avoid. So that's it for this month. I think the big lesson is get your IDV, your identity verification, completed if you are a director or a PSC of a company, so that you're all ready for the implementation date on the 18th of November. Thanks very much, everybody. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.